Swayam Prabha. Digital India. Educated India.
Good morning all. I am Professor K.D. Raju, Professor of Law, Rajiv Gandhi School of Intellectual Property Law, IIT Kanpur. In this NPTEL course, Intellectual Property Rights and Competition Law, this week we are going to discuss the concept of intellectual property law and different categories of intellectual property rights. We know that the concept of intellectual property law is very simple. It is actually says that it is the creation of human mind or an incentive for innovation, or it is a statutory right given by the government to the innovator or the inventor, or we can say that it is the fruits of creativity or it is an incentive given to the inventor by the government for a limited period of time. At the same time, we can see the different categories of intellectual property law, and in this particular week we are going to deal with patents, trademarks, copyrights, geographical indications, designs, integrated circuits and trade secrets. These are the 7 categories of intellectual property rights described in the one of the WTO agreement dealing with intellectual property law, that is the trade related aspects of intellectual property law. And you can see in this particular picture what they are saying. They says, all I asked was, can I patent my copyrighted trademark? So, these fellows do not understand what is a copyright, what is a trademark, what is a patent. So, in most of the cases the people have this misconception, what is a patent, what is a trademark, or they could not find any distinction between the different categories of intellectual property law. So, if you are not able to understand, yes, definitely you require this class. So, this week we will discuss the categories of intellectual property law. The IP philosophy, which we already talked about, the incentive for innovators. The entire regime of intellectual property law is in the TRIPS agreement and one of the WTO agreement, which provides minimum standards of intellectual property, but not uniform. Each and every WTO members, presently 164 World Trade Organization members have intellectual property laws in their domestic countries. They have to follow the minimum standards prescribed by this WTO agreement, which is known as the trade related aspects of intellectual property rights and known as TRIPS agreement, popularly known as the TRIPS agreement. And the nature, which we already discussed, that the nature of intellectual property is definitely it is a human creation of intellect. It is an intangible property. Earlier, every company is survived with tangible properties, but now every knowledge based companies survive with intangible properties. It is an exclusive right given to the inventor or the innovator or the artist or the writer or the author for a limited period of time. Under the TRIPS agreement, presently it is a uniform protection given to patents, especially the 20 years. This is very simple, because the objective of giving this limited period of protection is that after this particular period of time, everybody, the public, would be able to use this particular technology or this innovation. So, the exclusive right is given to the inventor for a limited period of time for it is an exclusionary use. So, intellectual property is there are a lot of definitions for intellectual property, but it is a clearly which says that we can say that it is the application someone used their mind or intellect to create something new. And we will see later on discuss what are the requirements of these criteria of intellectual property, but it is very clear it is the invention which is mostly appreciated under the intellectual property law, and it is a legal protection. Now, it is the obligation of every country to provide legal protection under the TRIPS agreement to this kind of innovations and inventions. So, if we look into the history, we can see that the concept of intellectual property is not new at all, and we can find prolific inventors in the past centuries, and one of such bright mind is none other than the Thomas Alva Edison, who contributed thousands of inventions, thousands of patents to the knowledge, and you can find his one of the inventions, some of the inventions which is still it is relevant, especially in the case of lights and other machineries. The purpose is very simple of intellectual property law. It is actually a reward or an incentive to the author. It is an incentive to the sweat of the inventor to do more and more innovations in the future. It is a stimulation to the artist. It is an incentive to the writer or the author. So, it is a recognition of scientific creativity. So, that is why we can find number of innovations in the market now. Now, the entire society is run on innovations. So, if each and every company, if you do not innovate, you perish. That is the present situation of the knowledge based companies. So, the rationale is very simple, which we talked about is one is the incentive theory, incentive for creativity, and other one which we can see that this is it is a monopoly right, limited monopoly right granted to people, those who innovate. This is an incentive for further innovation to the society. And there are criticisms also of the protection of intellectual property. They say that each and every knowledge belongs to the society. So, nobody can make it monopoly rights. But in protection of intellectual property also which is contributing to the society, because this monopoly right is granted to a limited period of time, and also the society what it gets out of it, and the inventor discloses this particular innovation to the society from the day one. So, that the limited period of protection is over, the society can use this particular knowledge for further innovation. And if you look into the Indian scenario, so we will come later on, but at a glance you can see India has complied with the TRIPS agreement and enacted or amended its laws in accordance with the obligations under the TRIPS agreement. So, we have Patent Act, we have Copyright Act, we have Designs Act, we have Trademarks Act, we have Geographical Indications of Goods Registration and Protection Act 1999, Semiconductor Integrated Circuits Layout Designs Act 2000, the Protection of Plant Varieties and Farmers Rights Act 2001. So, most of these acts came after the TRIPS agreement, that is came to existence in 1995. We amended our laws in accordance with it. So, the pertinent question is that why should you protect the intellectual property? Why should you protect intellectual property? So, I will give you some of the examples of, I will not say biopiracy, it is theft of our intellectual property, and one is the Basmati case, and other one is Haldi, and the third case is Neem case. So, the Basmati case is simple, and Basmati is a rice which is grown in many parts of India, especially some of the northern states of India, and it have a huge export market all over the world, and Pakistan is also claiming that the Basmati rice belongs to them as well. So, apart from the conflict or the conflict of interest between India and Pakistan, and one of the American company Rice-Tech in 1997, they filed a number of patents with the US Patent Office based on the biogenes taken from the original Indian basmati rice, and they want to patent it in the name of many names, and some of them were Kasmati, Taxmati, etc. So, it is nothing but the theft of Indian knowledge. It's India's intellectual property, which will come under one of the categories of intellectual property, that is the geographical indication. And this company was trying to patent it in the US, and the government of India has to fight the case in the United States, and finally, the US Patent Office revoked it. And the second case is on haldi, and haldi everybody knows that its medicinal qualities of haldi, and its wound healing, especially the wound healing qualities of the haldi. And in 1995, another the US Patent Office has granted a patent for the use of turmeric in wound healing. So, again we saw this Indian traditional knowledge, has been stolen by these US companies. Then again India has to fight this case in the US courts, and finally, this patent also was revoked. And the third case is on neem, and we know that the neem is used by Indians for many medicinal purposes for time immemorial period. And here also we can see another the US company WR case, they want to actually patent different products of neem involving neem and to make a monopoly for them. In 1985 onwards, you can find a number of patents that is a neem based products like toothpaste and other products, and where the patents were filed in the US PTO as well as in the Japanese Patent Office. In 1992, the WR Grace, this particular company, come out with a emulsion of pesticide emulsion based on the neem products. And once they made this particular, they patented this particular product, and they are started suing the Indian firms, those who are making this emulsion using the neem seeds, specifically the neem seeds. So, because everybody knows that the bio pesticides can be made from neem, and this particular knowledge is in India for a time immemorial period. So, India has to fight this case as well, and in not only in US, in other jurisdictions as well. And in 1997, this patent was rejected, and also in other jurisdictions like Germany is also the European Patent Office has accepted the arguments of Indian scientists that this particular knowledge exists for time immemorial period and in India, and Indian knows this particular knowledge. So, what does it mean? All these cases is what it is specifically mean by these fighting all these cases. So, if you do not protect your intellectual property, not only somebody is going to take away your intellectual property, and but also they are going to make it their own and make money out of this, and the patent protection on it, and they are going to have a monopoly right over your intellectual property. So, it is now your duty to protect your intellectual property. When you look into the different types of intellectual property, which I have already explained to you. So, under the TRIPS agreement, there are 7 categories of intellectual property which is mentioned in the TRIPS agreement, and starting with patents, then you can find copyright, then trademark, geographical indications, then integrate layout designs, industrial designs, and then finally, the trade secrets or undisclosed information. And in today's class, we are going to discuss about the patents. And everybody heard about patents, but they actually most of them are not aware of what constitutes a patent, what are the requirements of a patent, or what are the why you should take patent and why you should protect your inventions through patents. So, if you look into some of the old the technologies, so we know that the flying technologies or the first flying machine is invented by the Wright brothers. So, the Wright brothers, you can find the patent protection for their machine. So, they have patented some of these machines, and you can also find the old, some of the very old patents. So, the first ever old patent was granted, its invention was granted to John of Vietnam by King Henry VI, and that was in 1449. So, remember, the first patent was granted in 1449, that is centuries back. So, the concept of intellectual property or patent protection or it is new at all, not new at all. It is a centuries old concept of protecting intellectual property law. And so, you can find the coincidence that the first patent also was granted for a period of 20 years, and after many centuries the TRIPS agreement also limited the protection to 20 years of monopoly rights. And here you can see that. So, definitely you can find the first case the incentive theory. So, what he did is in giving a monopoly rights, he also written he has to teach his process to the Englishmen. That was the condition put by the king on the first incentive. So, the first invention itself, he got the incentive as well, and then so the patent system, the Indian patent system started from that onwards. So, you can see that the first US patent also was granted for potash, that was in 1790 to this patent number 1, which was signed by the President of the United States at that point of time for making potash and pearl ash by new apparatus and process. So, you can see the certificate granted by the United States President at that point of time. So, here you can see that. So, what I want to say is that the concept of intellectual property is not new at all. It is not the invention of the 21st century, it is centuries old, the concept at all. So, we use a very simple the clip, the gem clip which we used is patented in 1899. So, the patent clip it was invented by a Norwegian person, this Johann Waller in Germany in 1899. So, you can see that even a small thing, a simple thing can get a monopoly right only for a limited period of time, but the inventions, the innovations spread over many centuries, still we use the same gem clip after centuries. So, it means that even a small invention can go for centuries and centuries. And if you look into the first ever patent granted in India, and it is in 1856, 1856 that the Britisher and who was serving in Kolkata, whose name is George Alfred D. Penning, so who belongs to Kolkata at that point of time, has invented a machine, a mechanized system for moving a manual panga. So, he is with his invention, that is the George Alfred D. Penning. And earlier, before the fans which we use in the present states, present condition, there were manual pangas. So, this is you can see the manual panga on the roof, and some people have to manually operate this. So, he made an invention to operate this particular panga. So that was the first invention. So, you can see the transformation of the present fan from the panga, which is the manual panga, to the innovations, different innovations, and which reached to the present level of the fans which you saw nowadays. And you can I can explain a number of patents. Let us skip through all these inventions. So, you can find a number of inventions. For example, the sewing machine. The sewing machine everybody used the present day, which was the invented at that point of time in 1855 onwards. It is a patented machine at that point of time. Now, you can find new innovations to the sewing machine. And so, earlier also I talked about the Thomas Alva Edison, who have thousands of patents on different innovations. So, if you innovate, a prolific innovator who is a class dropout, we will come to the what are the prerequisites of the patenting. So, as I told you, when in many of the jurisdictions, inventions are patentable, and in India discoveries are not patentable. But the criteria for, as I already told you, that the TRIPS agreement only put minimum standards, not the maximum standards. So, some of the countries are very liberal in in inventions, and incremental innovations are also permitted in some of the countries. And so, the first criteria is patentable subject matter. So, which has to prove the basic three minimum criteria, that is novelty, then non-obviousness or inventive step, and third is the industrial application. So, if you look into these the three criteria, the novelty criteria, invention. So, it is a very simple criteria in layman's language. If I say that it should not be known to the public prior to the claim by the inventor, that is a very simple criteria of novelty. So, and the second criteria is the inventive step. That means, the invention would not be obvious to a person who is ordinary skilled in the art. So, if the mechanic, if it is a mechanical invention, a mechanical engineer or a person who is conversant with the technology should not heard about it before. That is the simple language, that is the inventive step or non obvious to a person. And the third criteria is the industrial application, that is the invention cannot be an abstract, invention must be useful, or it must be practical activity, or there must be an intellectual industrial application. So, the intellectual creativity must have an industrial application. These are the three conditions which is put forward. And there are under article 27 of the TRIPS agreement, there are many things which is excluded from, that is the patentability criteria is mentioned, excluded from the patentability. For example, the naturally occurring substance or elements are excluded. Then secondly, the diagnostic, therapeutic and surgical methods for treatment of humans or animals are also excluded. Then plants and animals and other than microorganisms. But there are controversies with regard to the plants and animals produced with the help of biotechnology. So, genetically modified organisms, in some of the countries it is patentable, and some of the countries these are non patentable. Then fourthly, the essential biological process for production of plants and animals are also excluded. Then again most importantly, the inventions which are contrary to the public order or morality is excluded from patentability. And lastly, which we can find that the mere ideas or methods for business, playing games, performing mental acts are not patentable in most of the countries, but you can find business method patents are available in the countries like the United States. And the most important requirement of the invention is the disclosure of the invention to the public. As I already told you, the inventor gets an incentive for a limited period of time for disclosing his invention to the public at large. So, the disclosure must be sufficiently complete, so that a person skilled in that particular art can duplicate that particular invention. Once the protection period is over, she should be able to practice. So, you can see that these inventions disclosure should be complete, so that this can make this. And you can also find the non patentable subject matter, and so a frivolous matter is a very small matter, is non inventable, so it is non patentable. And also these established laws, a machine which is made for opening of locks, So, the contrary to established natural laws are also is non patentable, and also other than commercial exploitation. So, or a machine which you invent contrary to public order and morality, or which causes serious prejudice to the human or animal or plant life or health or to the environment is excluded from patentability. Then again, so as I already told you that the mere discovery of scientific principle is non patentable in most of the jurisdictions, and abstract theory again is non patentable. Then already in the discovery of any living things or non living substance occurring in the nature is non patentable. But in some of the countries which you can find that it is a living organism, that there is a distinction between non living substance and living substances in some of the jurisdictions. And you can also you can see that the most, if you look into this particular picture, which you can find that the most important the inventions are in which are the areas where the most important inventions, whether it is in the automobile sector, whether it is in the lamps, whether it is in the other areas like telephone, or it is in areas like microwave or in the computer. So, you can find some very specific areas where there is a lot of innovations happening, especially 60% innovations happening in the automobile sector in car. So, this concentration which you can find, concentration of innovation can find in some of these specific sectors. I think this is a panoramic view of trends of the patents which you can find it in all over the world, and which are the areas where it is happening, where the filings are happening, and the grant is the grant of the total number of patents in different jurisdictions which you can find. So, these are the data which is created by the the specific people, which clearly says that the innovations are happening in the developed world, not in developing countries. I think the developing countries also has to now look upon the innovations more and more. And some of the companies, if you look into the data, some of the companies are prolific innovators, like the famous companies like Qualcomm, who is a major in the telecommunication sector, and General Motors, and these numbers are representative numbers and which may change, but clearly it shows that you can find other than CSIR, which is the Indian organization, Government of India organization, you could not find even a single Indian company in this long list. So, it means that the countries like India or the developing countries should more and more concentrate on innovation, and innovation, not only innovations, filing patents. So, all these companies are foreign companies. Why the foreign companies? So, the Indian companies also should come up and innovate, and they should file the patents. If you look into some of the institutions, they are also majors in filing patents. Definitely, it is the Indian Institute of Technologies, IITs are the majors in filing number of patents. And most importantly, you can find some of the private institutions are also in this particular figure, and these private institutions are also actively now coming up with patent filings, and they want to become the majors in this particular field. And I hope that these institutions, specifically the industry and institutional partnerships, can make the number of filings in India in very high. And these patent trends, which shows that specifically shows that the number of patent filings in India are going up. Number of, definitely it is going up if you take into account from 1995 onwards. And now also the filing procedure also very simplified by the Indian Patent Office. So, these when it come, but when the patent trends, when we compare it with the other countries, number of applications in our countries are very small. So, we have to innovate, not only we have to innovate, but the number of patent filings also has to go up, and then only we can come up, as we can say that we are an innovative country. And we will stop this particular class here, and this is about the patents, and we will go to the other categories next. Thank you.